Welcome to the Triple F Podcast. I'm Jim Hochberg. Today we're going to talk about Clarence Thomas at the U.S. Supreme Court and why he's being attacked and raked over the coals for taking vacations with somebody that's got a lot of money, and the rules that the Supreme Court came up with to deal with all the bad PR. But was it actually necessary and appropriate? Let's look into that. Well, Eva, hi.
Hi, Jim. I laugh every time I see anything have to do with the Supreme Court because I know that most of the time, you mentioned in a couple of shows ago that you don't watch all of the cases that come up before the Supreme Court. But I know that there are certain things that just get your attention. And I knew that this was going to be one of those things that were going to get your attention because you're right. Clarence Thomas has been getting a lot of attention.
And what isn't talked about, what's not covered in the news, what none of the politicians that are screaming and tearing their coats are even mentioning is, what actually does the U.S. Constitution require of the Supreme Court of the United States?
And I'm glad you're going to answer that because I have heard so many talking heads, people in the news, people in their Twitter, whatever, wanting Congress to rein in the Supreme Court. And I know how you feel about that. So
if you've been watching our show for a while, you know that we like these little Constitution books because we give them out.
We do.
And they hold the Constitution in them. So let's take a very quick minute to read what the Constitution of the United States of America says. Article 3, which is why we refer to federal court judges as Article 3 judges. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. And it talks about judges serving for life and that the compensation cannot be diminished during their period in office. And then there's a section on what they cover, which is cases and controversies. That's super important for us to think about, and we'll get back to that. And it talks about them not having jurisdiction over impeachment. That's what the Supreme Court is described as in the Constitution of the United States. And why that matters is the existence of the Supreme Court requires that we look where it was ordained, and it's in Article 3. Just like the presidency, the office of the presidency and the offices in the Congress are ordained, created by the Constitution. So what's interesting is we have a jurisprudential maxim of separation of powers within the United States government. What does that mean? That means the Congress passes law, the president and all of his departments in the executive branch execute the laws passed by Congress, and the Supreme Court hears and decides cases of legal dispute between particular parties.
And our founding fathers, in their wisdom, understood that in order to have a nation that was going to be fair and balanced, they created the balance of these three powers.
Well, and the distinct jurisdiction is that the executive branch, the president and all of his departments cannot regulate Congress. Congress cannot regulate the Supreme Court.
Okay, those lines have been blurred quite a number of times, Mr. Hochberg.
But no, what you actually need to do is think back to Dobbs, which was the decision that overturned Roe v. Wade in June of 2022, a year and a half ago. What happened? All of a sudden, when the leak of the draft decision came out, if we remember, there was a draft of the Dobbs decision that said it was overturning Roe. It wasn't official. It wasn't supposed to be leaked. Nobody ever knows about drafts of Supreme Court opinions. What happened? Remember, the residences of the 9 Supreme Court justices had people protesting in the streets.
Not all of them.
Well,
just the ones
Kavanaugh,
whose position people didn't
and then
like.
Thomas started getting attacked for his vacationing with some rich guy. I don't remember the guy's name. And what was happening, and this is really important, and it bothers me, and I hope that you'll take the time to listen and think about it. The Supreme Court is not like the Congress and the executive branch. Congress creates law, they create policy for all of us, and for the execution of those laws, the president and all of his departments do their work. They have certain kinds of opportunities behind the scenes to cheat and to be bribed and to take undue influence from groups and stuff like that, which is why they have to report gifts and contributions and all that kind of stuff. The judiciary decides cases between disputing parties in a legal litigation case. It's those parties. Now, granted, we've talked about it before. Roe v. Wade was about Mrs. Roe and whether she could get an abortion or not. But it ended up affecting 50 years worth of 6 million or 60 million or 100 million, however many babies were aborted because of the ruling. But the justices are not supposed to be setting policy for the country. They're deciding a case or controversy. So who they go on vacation with is meaningless unless the guy who bought their vacation ticket has a case before them.
So a lot of
Well, wait a minute. If the guy that they went on vacation with has a case, they have had a rule since the founding of the country, they recuse themselves. All judges in all courts are supposed to always be impartial. So to be impartial, you can't rule on a case for your friend. That is the background for these threats to have Congress regulate the Supreme Court, would require an amendment to the U.S. Constitution.
Well, I think with all the craziness that's happened since Roe, and actually there was some crazy stuff that happened before Roe, but it's like the attention was on it because of what was happening, because of the leaked decision. But
if it wasn't abortion,
it wouldn't
have mattered.
No, right. Because that's what I said. The ones that were targeted were the ones who the decision was not tolerated by a certain group of society. But I think it shed the light on something that maybe a lot of people didn't know, is that the Supreme Court has a code of ethics. They've had a code of ethics for a long time. But because of these things, people were starting to say they needed to do more. They needed to regulate themselves and all this kind of stuff. So
that's kind of true, but it really isn't. The federal judiciary, the Article 3 judges that the Constitution says the Congress can ordain and establish, the lower courts. The Constitution creates the Supreme Court, 9 justices. Almost said 9 guys. 9 justices on the Supreme Court. The courts of appeals below the Supreme Court, and all of the federal district court judges and the bankruptcy court judges in the federal system are ordained, created by Congress. Those lower federal court judges have long had a set of rules that are just like the rules in the state of Hawaii judges.
But didn't the Supreme Court have their own set of...
There's 9 justices.
Right.
And they all know each other. And they are very fine at self-regulating. There's 9 of them. You got to be kidding me. So they didn't have what they have now because they didn't need it. A judge needs to recuse from hearing a case if they can't be impartial because of a relationship or an investment or whatever.
So that's just a rule that apply to all judges, period. Or attorneys too? Do attorneys? No. Attorneys have code of ethics too, don't they?
Yes, we do. And we're also not regulated in the state of Hawaii by the legislature or the executive branch. This is very interesting. People might not know this. If you want to get a law license is a license granted in the state of Hawaii. If you want to be a contractor, you need a license. If you want to sell insurance, you need a license. If you want to sell real estate,
You want to do therapy.
if you want to do haircuts or facials or massage. I mean, we have
Tattoos,
so
right?
many state issued licenses. Almost all of them are regulated by the Department of Commerce and Consumer Affairs. Lawyers are not. Our license comes from the Supreme Court of the state of Hawaii, and an office within the Supreme Court called the Office of Disciplinary Counsel regulates lawyers. Why? Because of the separation of powers. Same thing at the U.S. Supreme Court. So all of this brouhaha in the pro-abortion lobby across the country against Justice Clarence Thomas because there was nothing wrong with him going on these vacations. So he probably had him on his Facebook page. I'm not on Facebook. I have no idea. But that's what I understand people do. So anyway, somehow these pro-abortion Soros-funded folks started complaining bitterly about Justice Thomas having to be kicked off the court because he goes on these vacations, which was completely fine for him to do as long as he didn't hear a case that involved those vacation friends, which every judge except the one hearing the Trump fraud trial in New York they always kick themselves off. They recuse. So anyway, in November of this year, because of all the screaming, gnashing of teeth and things going on in the pro-abortion part of our country against Clarence Thomas, the Supreme Court in November announced for the very first time that it had adopted a formal code of conduct governing ethical behavior of the 9 justices. And there's a Reuters article written by Andrew Chung and John Critzel describe it this way, that the U.S. Supreme Court on Monday announced its first formal code of conduct governing the ethical behavior of its 9 justices, bowing to months of outside pressure over revelations of undisclosed luxury trips and hobnobbing with wealthy benefactors.
And shouldn't that scare people when you really think about it? When you have the highest court in the nation becoming
Bowing to
scared,
politics.
right? Because they're afraid of what people might think and do. I mean, not to say that somebody can't be a crook, right? I mean, you would hope that somebody on the high court is not, right? And so we would hope that the ones being appointed and then the Senate confirms, we would hope they would be good people.
My recollection is when Nixon was president, he nominated a guy whose name I can't remember, who got on the Supreme Court and took a bribe and got kicked off the Supreme Court. The way you kick a justice off the Supreme Court is if they don't voluntarily resign, it's an impeachment, just like President Trump went through 3 times. Trump wasn't convicted by the Senate, so he stayed president. I can't remember the guy's name, but I believe he resigned in lieu of impeachment because he got caught taking a bribe on a case. But so there's a code that is now binding on the justices, which they put on themselves.
But it's self-regulated.
That's the point that I want to make sure everybody realizes.
So it really doesn't mean anything.
Well,
The sense that they're going to continue to do what they've always done. They just have it in writing now. I mean, what has changed? Nothing.
If we were in court and you made that statement, I would say, objection, Your Honor, calls for speculation. How do I know what they're going to do in the future? Do you?
No, I'm saying that now that they have this written, what is going to change? Nothing, right? They're going to continue to self-regulate. I mean, that's the bottom line is it's self-regulated.
So here's the things that their new code says. And I'm going to be asking you, do you think they weren't like this before?
Well, my answer, I can already tell you.
So canon number 1. And all good Catholics know that canons are very important points of authority.
They are.
Canon number 1. And the question is, do you think they've never done this before and they're going to start now? A justice should uphold the integrity and independence of the judiciary.
Nothing's changed.
Canon number 2. A justice should avoid impropriety and the appearance of impropriety in all activities. Respect for the law and outside influences, non-discrimination, membership. Those are the subcategories. Do you think they ever were failing to avoid impropriety and the appearance of impropriety in all activities, respect of the law, outside influences, or discriminating memberships?
No, but it's clear
so.
now. It's in black and white now.
Canon number 3, a justice should perform the duties of office fairly, impartially, and diligently. I'm serious. I mean, this is so frustrating to me because it's all politics in violation of this guy.
Well, I can tell you that because I've been watching a lot of the chatter from some of the attorneys that they're not happy with this because they say nothing is going to change. That this is not going to suddenly make any difference to them. And they want Congress. This is what I'm hearing. In their Twitter posts and all that, they're asking that Congress make a law.
They're idiots.
I don't know how.
They're idiots. They have to amend the Constitution.
Yeah, I don't. I was going to say I don't understand. And these are attorneys that are saying this.
They're pro-abortion political activists doing activism even though they have law degrees. Well, it's not legal. Well, it's not lawyering.
Well, I wouldn't speculate that they're abortion people that
the reason that I am willing to
but,
is because that's where this all came from.
Well, but when I was reading a lot of their complaints, they were talking about all these gifts, monetary gifts that Clarence Thomas allegedly received.
But it's okay as long as the person that gave him the gift doesn't appear in a case.
Yeah. So I do
That's
hear
the difference between the Supreme Court justices, the 9 of them.
Yeah.
And the 438 or whatever members of Congress and the 100 senators and all the people that work in the federal government. It's cases or controversies. So the opportunity for bribery is a case by case. In those other branches of government, it's huge. But there are more canons. Let me ask you.
Okay.
Do you think this has never happened before and it's going to start now? A justice may engage in extrajudicial activities that are consistent with the obligations of the judicial office. I went to the UH Law School, William S. Richardson School of Law. There has been a Supreme Court justice almost every year during a semester somewhere as a jurist in residence from D.C. for a period of time, not every month. Always the liberal ones, you might guess. That is engaging in extrajudicial activity. It's called education that are consistent with the obligations of their judicial office. So nothing illegal about it. They're not running for office. They're not, right? Okay. There's still more.
Well, okay. So, but let's make this clear. It doesn't matter how many of those you read, right? If they do something against what's in there.
They're self-regulating.
Right. So, I mean, the other justices would have to say, hey, Jim, I don't like that you've done this and here's the reason we think that way. But it's still, I guess that's why people that are not happy with this are saying, what good does that do?
Well, here's the good one. I like the last one, Canon 5. And I would ask you to think about why this one is important in relation to why they had to do the whole thing to start with. Canon 5. A justice should refrain from political activity.
You know what? And I'm going to say this, and I don't care if I get hate mail. I like that they did this. I like that they put it in writing, whether it's self-regulated or not. Okay, that's fine. I like that they put this out there in black and white so that people will see this is how we conduct our lives. If it's not going to change anything, I don't understand what the problem is.
Okay, so self-regulation of the judiciary has been going on in the state of Hawaii since at least August 29th, 2008, when the Hawaii Revised Code of Judicial Conduct was published, and it was amending the September 9th, 1992 version. So in Hawaii, there's a judicial code of conduct. And guess what the provisions are? You'll be amazed. I think The Supreme Court of the United States plagiarized the Hawaii Code of Conduct. It's exactly the same.
I only know one other person that whispers in the mic.
That's why I did it. So the point is, for the people that are complaining that what you just said, they made this up, they're the ones in charge, it's meaningless, and people still want Congress to act. The judiciary in the state of Hawaii, so I'm assuming it's the same in all the states, although I could be wrong, because in some states, we actually, the people elect their judges in the state system. We don't elect any federal judges, but in Texas, I think they elect their judges. So there is a public participation enforcement, because you can not reelect somebody, or you can run against them and beat them, or that kind of thing. But the Hawaii Code of Conduct, Canon 1, a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Did we not just hear that in the Supreme Court's new ones, right? Mm-hmm. Okay. Canon 2 for Hawaii, a judge shall perform the duties of judicial office impartially, competently, and diligently. We heard that in the Supreme Court's new thing. In Hawaii, Canon number 3, a judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the duties of judicial office. We heard about that in the new set of rules that the Supreme Court created for themselves, right? So, Canon 4, a judge shall not engage in political activity that is inconsistent with the independence, integrity, or impartiality of the judiciary. We heard about that in Canon 5, right? If the judicial system in the state of Hawaii since 1992 has been self-regulating, have we heard people screaming, yelling about judges, anything in Hawaii? We've both been here since decades earlier than that.
And as you know,
of course not.
And as you know, that's one of the things that drives me crazy. Why can't we just be consistent? If there's people have a problem with this, then why don't they go across the board and have a problem with all the other states that are doing it? I find it quite amusing.
Well, and the thing is, if Congress is going to regulate the Supreme Court, what does that do to the impartiality of any case that involves anything that is dear to a congressman?
Well, may I quote from Bloomberg?
Yep.
They had their editorial board wrote on this very thing. And I knew you were going to bring this up. So I thought, perfect quote for Jim to react to. All right. So this came out again from Bloomberg on November 27th. And the title is U.S. Supreme Court Still Needs a Real Ethics Code. So that's the title. This is what
Which means the state of Hawaii's ethics code is no good either.
You can write to the editorial board. In fact, I challenge you to write to the editorial board. I think that'd be great. We could talk about it on the show. Okay, so this is an excerpt. Quote, the Constitution provides lawmakers with broad latitude in regulating the judicial branch. And the legislature has a long history of imposing requirements on the high court, including mandating recusals in cases where justices' impartiality could be questioned and requiring disclosure of their financial holdings and outside income. And then at the end, they
is there a footnote to that?
No, there is.
I want the source of that, because it's not the justices of the Supreme Court. It's
they don't have a footnote, but they do
courts.
have a link. So let me see where it links to. And this comes from the uscode.house.gov.
Okay.
Okay. And they do have section. So this is 28 U.S. Code 455, disqualification of justice, judge, or magistrate judge. And it's from section 455. So you'll have to, it's quite long. I don't want to bore our listeners, but you can look that up after and see how that ties in. But they end the editorial saying this, and I think this is their synopsis of what they're saying. Quote, it is now up to Congress to hold justices accountable. In drafting legislation, lawmakers should strive for bipartisan consensus, which shouldn't be hard, given that bipartisan nature of the court's ethical breaches. They should also take care not to allow ethics enforcement to become politicized, but they can't let the court's blindness to its own injustice continued unchecked. End
So
quote.
there is a huge move, and this is my response. There's a huge move, and has been in this country for decades. It's getting stronger and stronger recently to do away with the Constitution. Governor Newsom in California wants to get rid of the Second Amendment. He thinks that that's the way to solve the problem with firearm deaths. It's stupid. The people that are killing people with guns don't care what the law says. It's unlawful to kill people with guns. They really don't care about it. But anyway, if you disrespect the separation of powers of the Constitution, it's fine then for you to think we don't need separation of powers and we want Congress to regulate the Supreme Court. The problem is the Constitution only gives Congress the power to regulate the inferior courts within the federal system, not the Supreme Court.
So why do you think they fight so hard against having a con-con? You figure if they really want to do all this, why don't they do it the right way?
Well, I participated in the Convention of States in this past summer.
I know you did.
And that's the other way to do it. And I am, in fact, Newsom in California is supporting a convention of states out of Article 5 of the Constitution for the purpose of removing Second Amendment.
And that's why you have some people that don't want a constitutional convention, because they don't want it to be opened up for all this crazy stuff. But so what's the call to action? Is there a call to action?
So the call to action, when people are complaining about the Supreme Court justices, the 9 members of the United States Supreme Court, what we have to remember is our system of government demands and requires and depends upon their independence from the political elected people, because when inflamed political rhetoric moves policy in a bad direction, that cannot impact the Supreme Court. The fact that they overturned Roe v. Wade was a legal decision, and it was a very well-reasoned one. And at the same time, Roe was a terribly reasoned legal opinion. It had nothing to do with the law. It was a political move. It's terribly important that the Supreme Court of the United States remain independent and not worried that Congress will do something to them, which is why we noticed in Article 3, Congress can't change their pay while they're on the court. They can only change the pay for people that aren't yet on the court. It's really critical that separation of powers and the ability of the Supreme Court to be independent is maintained. Otherwise, people like Chuck Schumer, who stands in front of the Supreme Court and threatens them to reap the whirlwind, will actually mean something to them because they can be regulated. Right now, they can't be, and that was just stupidity on his part.
Well, we appreciate that you took the time to listen in this crazy week before Christmas. You're all shopping and trying to do all that last minute stuff. Like this video, you share it, you subscribe, hit that notification button so you know every time we upload a new video. And sit with us next week as Jim and I have a fireside chat on Christmas. Well, on the week of Christmas. We'll see you then. Mahalo, everybody.
Aloha.